So welcome to our company law class, and we are continuing with our discussion of shares as part of corporate finance. Specifically, we want to continue with discussion of the segment of shares we call the doctrine of capital maintenance, particularly looking at what we call the prohibited transactions in shares, stated capital, dividends, and also matters pertaining to capital reduction. So we propose to discuss, analyze, and reflect on sessions 58 through to session 82 of the Companies Act 2019, Act 992. And we hope that by the end of this discussion, you should be able to explain the capital maintenance rule, and in particular, why it underpins the various statutory restrictions on transactions in shares. Again, you should be able to identify and apply the core prohibitions in section 58. Particularly, I think there are about 4, if you like. The core prohibitions, adumbrated in the section 58, as it were, 58(1)(a) today. And again, you should be able to apply the exceptions which are provided to the core prohibitions in section 58, particularly the exception like alteration of number of shares under section 59, financial assistance exceptions under section 60, and then lawful acquisition of own shares by the company under sections 61 to 67. And again, students should be able to define stated capital, reserves, and retained earnings, and develop the understanding to be able to apply them to legality of dividends, and then lawful redemptions of redeemable preference shares, buybacks, and capitalization issues within sections 68 to 77 of Act 992. And finally, we should be able to explain and apply a court-confirmed reduction regime. In other words, how can stated capital be lawfully be reduced? And the law has provided that the court should involve in order to supervise the process so as to ensure fairness and compliance with the spirit of the capital maintenance regime, and particularly protection for creditor of the company. So the basic organizing idea, the driving framework of all this is what we call capital maintenance. The whole point about these sessions, I think 58 to session 82, as it were, is capital maintenance. That is the reason why we have this framework there. And what is that core principle and the mischief which it seeks to address? So, those who were in the classroom when I was in Kumasi a couple of days or weeks, we had an in-person class. We explained this, but because the regular class, they were not here, indulge me to repeat some of the points that I have explained already so that all of us will be on the same page as far as this aspect of company law is concerned. So I just made the point that section 58 to 82 is actually a statutory implementation of the common law doctrine or principle called capital maintenance. And we explained that. And the basic point is that share capital is not a free pool for shareholder extraction. In other words, the monies which have been raised by giving out shares it's not just money which are there, which shareholders can just take and use as they wish. Rather, it is part of the creditor protection architecture of the company. Creditors have done business with the company, either put money in it, and later we'll be discussing debentures, long-term lenders to the company, or normal trading creditors. They have done various transactions on credit basis, and they do so with the understanding that the company is more or less a going concern. That is to say that the company has the requisite solvency to be able to pay its debts and liabilities as they become due or as they are supposed to be paid. And that is the basis, the premise on basis of which these creditors deal with the company. And if that is so, it is imperative for monies raised from issuing capital, shares, what you call the stated capital, not to be depleted, not to be abused anyhow. And the story goes back to the old case of Trevor and Whitworth. Trevor and Whitworth. Trevor and Whitworth, 1887 to appeals cases 409. It's a House of Laws decision, and that case, basically, a company purchased a substantial portion of its own shares, and ultimately, when it was challenged, the court, the House of Laws, made the point that such a buyback is ultra-vires and under the then regime, the law at the time, because it would allow the company to return capital to shareholders. If you are buying back, shares, you are giving money back to the shareholders, and that will be injurious or will be prejudicial to the interests of creditors, and it will undermine what the law has provided to guard against capital reduction. And for that matter, the position of the law in Trevor and Whitworth is that, or what they call the capital maintenance rule in Trevor and Whitworth, is that the monies, the capital which the company has raised by issuing shares, should be conserved for the good of the company and its creditors. And it should not be depleted, should not be reduced, except trading losses. Of course, once the company is in a business trading, if you are trading, you can make a profit. You can also make a loss. Now, if the company should, for example, make a loss as a result of normal trading losses, that is legitimate, and it is not seen as a violation of the rule in Trevor and Whitworth, or what they call the capital maintenance doctrine. So that is the basic thesis or proposition, that once you have raised money, as we've discussed in the previous classes, once shares are issued, monies should come to the company. There should be cash or non-cash consideration, properly valued. It should come to the company. If that is so, that should be kept in the company. It should not just be dissipated anyhow. So that is the bottom line. And this, Trevor and Whitworth actually provides the basis why in a lot of company law legislation, including our old Companies Act 1963 at 179, which has been repealed and reenacted as a Companies Act 2019 Act 992. We have provisions which actually seeks to prohibit the company from own share acquisition outright, or it provides a very tight safeguards regarding how the company can actually acquire back its shares, as we'll be seeing very soon in looking at section 61 to 67, as well as the rules pertaining to shareholders account very soon. So the bottom line, and I will encourage you to read chapter 19 of my very good friend and mate's book, Modern Principles of the Modern Principles of Company Law in Ghana. Ferdinand Adaje is a good book, and then he discusses some of these matters well too. So try and get copies or go to the library. The copies there you read as well, particularly chapter 19. So the point we should note here is whether a transaction is prohibited in substance, not their description. And so that's what, so if you are thinking about capital maintenance, as we'll be looking at the law, what we should actually concern ourselves is with, if you look at the substance of the particular transaction, can we say that it's prohibited by the law and not just the label or designation given to it? So let's keep that in mind. So on that basis, we quickly come back to section 58. As I say, for the sake of the other class that did not join the in-person, we have to repeat to ourselves quickly. So if you look at section 58, that is the general prohibition, and that captures the essence of the rule in the Trevor and Whitworth, the capital maintenance doctrine. And section 58, yes, we can read section 58 1 for us, subsection 1.
Section 58, subsection 1, prohibited transactions in shares. Except as provided in this act, a company shall not A, alter the number of its shares or the amount of money remaining payable on those shares.
Yes, continue.
B,
Yeah.
release a shareholder or former shareholder from a liability on the shares. C, provide financial assistance directly or indirectly for the subscription or purchase of the shares of the company or the shares of its holding company. Or D, acquire by way of purchase or otherwise any of its issued shares or any shares of its holding company.
Good. Now, if you look at section 58.1, all the four things which are provided there, you notice that they are capable of becoming what they call a disguised capital reduction. They can be a way of indirectly reducing the capital of the company, or a disguised distribution, that is an indirect way of sharing the company's money among the shareholders. And that is why they are generally prohibited. And I'd like you to pay attention to how the provision is structured. You know, there's a chapeau or the opening portion, except as provided in this act. Except as provided in this act. Now, what that means is that, yes, section 58, subsection 1, A to D are general prohibitions. Nevertheless, there are some instances in which these provisions may be circumvented, or in which the things provided in these prohibitions may be done and yet will not be considered as a violation of the capital maintenance doctrine. In other words, as a general rule, these four are prohibited. However, if you can get a relevant provision in the Companies Act, Act 992, directing you how you may do any of these prohibited things, then you will not be caught with a violation of capital maintenance doctrine. What you'll be doing is permissible. But if there's no provision directing you how you can do any of these prohibited things, then you cannot do it. And if you do it, you are sinning against the general prohibition rule in section 58. You are sinning against the doctrine in Trevor and Whitworth, what we call the capital maintenance doctrine. And for us to know how serious the lawmaker is about these things, it has gone on to ensure that, because it's very easy, to use certain legal devices. For example, to use trust arrangements or nominees. You can create like a trust, and then you allow the trustee to come and acquire something, and that will be an indirect way of trying to circumvent the law. And that is why, if you look at section 58, subsection 2, it captures nominee or trust devices. And it's to the effect essential that you cannot avoid the prohibition by registering shares in another person's name while the company is beneficially interested. So the company cannot be the beneficial interest of the share and just allow it to be registered in another person's name. And that is why section 52 says that if shares are acquired by the company, if they purport to be held in trust for the company, although they are registered in the name of the companies, is actually caught by section 58 1D, that the company cannot acquire by way of purchase or otherwise any of its shares or any shares of its holding company, as the case may be. So when we say like the holding company, we are talking about the group of companies phenomenon, the parent company, the subsidiaries, and so on. All those things are prohibited. And of course, if you violate these prohibitions, there are serious consequences. So if you look at section 58, subsection 4, with respect to section 58, 1A or B, that is, if the company decide to alter the number of its shares or the amount of money remaining unpayable on the shares issued, it is void and is not considered valid. So it's a nullity. And officers who are responsible for that, they incur administrative penalty. Will be fined by the Registrar of Companies. And again, if the company decide to sin against section 58 C and D, that is the rules against provision of financial assistance or the rules against acquisition of a company of its own shares, the transaction is voidable by the company, and certain repayments will have to be done, and also interest and some penalties will be made. So all these are meant to protect innocent outsiders in certain circumstances. So for example, if the company has, let's say that provided certain money to, let's say, brokerage firms, as will be seen later on, over and above the percentage which is allowed, section 10%. Yes, the third party or the outsider cannot be blamed, but those who are in charge of the company will have to bear the consequences, as it were. So let's look at the section 58(1) talk about except as provided in this act. So let's look at some of the provisions relating to how you'll be able to do some of the otherwise prohibited things in section 58. So let's start with section 59, alteration of the number of shares. Yes, please read that for us quickly.
Section 59.
Yes.
1. Subject to subsection 3, a company may A. Increase the number of the shares of the company by creating new shares, or B. Reduce the number of shares of the company by cancelling shares which have not been taken or agreed to be taken by a person, or by consolidating its existing shares, whether issued or not, into a smaller number of shares. 2. On a consolidation of shares, A. The amount of money paid. B. An unpaid liability on the shares. And C. A fixed sum of money by way of dividend or repayment to which the shares were entitled shall also be consolidated. 3. Unless otherwise provided in the constitution of a company, the directors may issue shares with rights or restrictions as may be determined by the directors, subject to the provisions of this act.
Good. So if you look at section 59, is directly referable to section 58 1A. Section 58 1A entirely said that a company shall not alter the number of its shares. Now, section 59 is directing how a company may alter the number of its shares, and it will not be considered as being in violation of the general prohibition. Now, what is important to watch with respect to section 59 is that it's not so much about the arithmetic, the arithmetics of the issue shares in isolation. No, capital maintenance is not concerned about the number in abstract, but whether the alteration is being used to create a disguised change in liability or the capital structure. So if the company is going to increase the number of shares of the company, there's no problem necessarily. But then, is it going to change the capital structure so that certain class shareholders would be disadvantaged, or what? Again, there's a talk of consolidation, and those who were in class, I use the analogy with Ghana's redenomination. When we decided to redenominate the old Ghana cedi to the new Ghana cedi, we decided to say that 10,000 old Ghana cedis will be equal to 1 cedi. And we used to say that the value is what? Is the same. So, therefore, in the same vein, it is permissible for a company to say that it wants to consolidate its shares so that instead of having huge numbers of shares, it will become simplified. Now, if that is the idea, there is no problem. But there is the risk that the company may hide behind consolidation in order to bring about diminution or reduction in liability of some shareholders, especially those who may have unpaid liability. Now, as we noted with the discussion earlier on of issue of shares and payment of shares, we noted that shares are issued as an agreement, and the company may say that you don't have to pay the full value now, only a portion of it should be paid, and then the other unpaid value will be called for later. Now, we do not want the company in a situation like that to use consolidation to allow shareholders who have, for example, unpaid liability to be able to get away with it and don't pay it. And that will be an indirect reduction of the stated capital of the company. And that is why section 59, no, 2 and 3 is telling us in substance that where there has been consolidation, it's not going to affect the amount of money unpaid in respect of the shares which have been consolidated as it were. So, for example, if we're having 10,000 shares, and the company said that they're going to do consolidation so that 10 shares are now to be consolidated into just one share. So if you have 10 shares, it will now be considered as what? As one share. Now, if we apply that formula to the 10,000 shares that somebody has, that 10,000 shares is now going to be, is it 1,000 shares? I think it will be 1,000 shares, isn't it? Yes. So 1,000 shares. And according to section 59, monies which remain, for example, unpaid on the 10,000 shares, which have now been consolidated to, let's say, 1,000 shares, will be the same amount of money applicable to the 1,000 shares. So let's keep that in mind. Okay, so let's move on to financial assistance section 60. Somebody.
Section 60.
Yes.
Section 58 does not prohibit any of the following transactions. A. The payment of commission or brokerage to a person in consideration of that person subscribing or agreeing to subscribe, or procuring or agreeing to procure subscriptions for any shares in the company, where the payment of commission or brokerage does not exceed 10% of the price at which the shares are issued, or lesser rates as may be specified in the constitution of the company. B. Where the lending of money is part of the ordinary business of the company, or lending of money is the ordinary course of business, although the money may be used for the subscription or purchase of shares in the company or its holding company. C. The provisions by a company of money for the purchase or subscription of shares to be held for the benefit of persons genuinely in the employment of the company or an associated company, including a director holding a salaried employment in the company or an associated company in accordance with the scheme for the time being in force. D. The advantage by a company of loans to persons. The advancing by a company of loans to persons other than directors, generally in the employment of the company, or an associated company with a view to enabling those persons to purchase or subscribe for shares to be held by themselves beneficially and not as nominees for the company or any other person. E. The payment by a company of a lawful dividend on the shares of the company, although the dividend received by a shareholder is used to discharge a liability on the shares of that shareholder or to repay money borrowed for the purpose of subscribing or purchasing shares. F. In the case of public company, some or all of whose equity shares are dealt with on an approved stock exchange, or in respect of which an application has been made to an approved stock exchange for permission to deal in those shares, the payment of any commission, fees, costs, and expenses, and the giving of any indemnities and warranties in each case to a person arranging or otherwise involved in an underwriting, placing or sale of securities in the company, or any other similar transactions where an application for permission to deal in those securities has been or is to be made to an approved stock exchange, and any other financial assistance is given in good faith in the interest of the company.
Right, thank you. So section 60, as you look at the opening part, it says that Section 58 does not prohibit any of the following. If you remember, Section 58, subsection 1, C. Section 58, subsection 1C made a prohibition of provision of financial assistance for the subscription or purchase of the company shares or its shares of its holding company. Now, what Section 60 is saying is that, yes, if you follow the stipulated conditions in Section 60 strictly, then despite the fact that what is provided therein from Section 60A to F would appear as the company giving financial assistance, it will not be deemed or reckoned as the prohibited financial assistance. It's not that type of financial assistance which is prohibited. But where you do not comply strictly with the procedure provided therein, then you have indulged in the financial assistance prohibited under Section 58 1C. So first and foremost, when we say financial assistance, we need to appreciate that it includes direct or indirect support for enabling a person to subscribe for or purchase the company shares. So if you provide any direct support or indirect support to enable or help a person to subscribe for that is acquire or purchase the company shares or shares of a holding company, that is a company related to the particular company you're dealing with, especially within the group structure. That is a financial assistance. So typically, it will include maybe giving loans or providing guarantee to loans or financial arrangement to enable someone to acquire shares, or security, or some arrangements that effectively will provide financing for the acquisition of shares. So all those things are considered as financial assistance. And the question is, why does the law prohibit these financial assistance? Now, the financial assistance prohibition in terms of Section 58 1C exists primarily because if you are finding or providing no financial support, if you are funding the acquisition of shares using the company resources, it can deplete the asset pool available to creditors. Creditors know that the company has got a certain asset. If for nothing at all, the shareholders' funds, the monies that the shareholders have provided as a result of the shares that were issued to them, they are there in the company. And together, the other assets they used to acquire. So should it come to very critical stage, the creditors have something to look forward to. But where you have actually given financial assistance in any of the ways that we have alluded to, you have actually depleted the asset pool available to creditors. Again, providing financial assistance can also facilitate controllers stripping value. Strip value, meaning that the people have shares, but the shares, they don't mean anything. They are more or less empty shell. They are more or less empty shell. And when it comes to what we call the takeover, okay, when it comes especially corporate mergers and acquisitions, that is also very dangerous because providing funding from the company resources in as far as acquisition of shares is concerned can actually enable what we call the leverage acquisition, where the target assets secure its own takeover price. especially if you look at the stock exchange, there are some rules which says that where a shareholder, as for example, build share up to a certain stated amount or quantum, then it can stake a takeover bid to take over the company as it were. Now, when that happens, it will have certain ramifications, including governance. The directors of the company, for example, to be taken over as it were, may probably lose their directorship or some other favorable arrangements, and they may not want that. So they may want to quickly provide either money for others to be able to acquire shares of the company so as to prevent or block the potential takeover. So these are some of the challenges. And if you look at the case law, I mean, especially we don't have much from our own jurisdiction here. But if you look at the UK, for example, in the case of Brady and Brady, Brady and Brady is the House of Lords decision of 1989. The House of Lords made it clear that when we talk of assistance, it can be direct or indirect. It must be assessed in context. And the court made a point that you don't just be excused from the rule which prohibits financial assistance simply by doing a clever structuring, structuring the arrangement of financial assessment in a very clever way, so that you are not deemed or you are not reckoned as having provided financial assistance prohibited by Section 58(1)(c), as it were. It is more importantly the effect or the substance, no matter how you've structured it. If the effect is to assist share acquisition, then you could still be brought within the rule which says that do not provide financial assistance unless you have complied with the laid down requirement. So look at Brady and Brady, B-R-A-D-Y, and then B-R-A-D-Y, 1989, AC 755. And for that matter, if you look at section 60, as he read nicely for us, you notice that the law has provided a closed list in the sense that list of activities relating to some funding to acquire the company shares, which are not considered prohibited. So these the list, I think there are about 5, as it were. No, I think there's 6. A, B, C, D, E, F. There are 6. So if you look at the 6 things provided under Section 60, so long as you undertake them within the strict parameters set in Section 60, you are not considered as having violated the rule against financial prohibition under Section 51(1)(c). And some of them, even when they are scrutinized, you notice that they are rather augmenting or strengthening the capital position of the company, rather than the company being made to lose capital, as it were. So let's look at some of them. He talked about the fact that if the company provide the commission or brokerage, okay, commission or brokerage, we are talking about, the company needs people to acquire shares. We have experts or entities, brokerage firms like agencies, whose business is to look for potential investors that have ideal funds they would like to invest, and also to look for companies or businesses looking for critical funding, and they bring them together. So these brokerage firms or these agents, in doing the work that they do, so as to help the company to get shareholders, they must be paid for their services. So they take a commission. Just as in the real estate industry, you are a prospective tenant, you are looking for a room to rent. You don't know, places where there's available room or houses for renting or letting. Or you want to buy a house or land or whatever, you don't know where some are available. We have people whose business is to collect information about all this and trade that information. So they are the real estate agent. So if they take you to a place where there's available place to rent, for they providing that service, you have to pay them because that's how they also live. In the same vein, when it comes to the company giving out shares, those businesses or companies like the brokerage firms, brokers, jobbers, whose business it is to look for prospective shareholders, they too will have to be paid for the services that they are doing for the company to get shareholders to subscribe for their shares. So what they are paid is the commission or the brokerage fee, as the case may be. Now that certainly looks like distribution of value. It looks like the company sharing its money. So there's a risk there. There can be a reduction of the capital of the company if there are no checks. And that is why there is a cap. There is a limit or ceiling, which has been set by the law, that the company should not pay more than 10% of the value of the money is going to get from issued of a particular shares to whoever assisted the company to get a shareholder. So if the company is going to use services of others to be able to get shareholders or subscribers at all, the company should not pay more than 10%. If the company did that, that will be considered as a violation of the rule against providing financial assistance for acquisition of shares, because you've gone outside the parameters. But if you stay within the 10%, it's not considered as a violation of the financial assistance. So let's keep that in mind. Then he also talked about the second scenario. That is ordinary course lending, like companies whose businesses is to actually lend money. That is the ordinary business. It's not the case that it's just creating a one-off disguise assistance by creating a loan to enable somebody to acquire shares, but it's ordinary business. What it does as a business is to provide loans, lending, maybe like bank or any other lending institution. Now, if you take a loan from such a company or such an entity and use it to buy that company's own shares, because the ordinary business of the company is to give out loans, it is not considered as the company providing financial assistance prohibited under Section 58(1)(c). So let's keep that in mind, because that is the business of the company. In any case, because the ordinary business of the company, the loan that you've taken, you pay interest on it. So if you decide to use the loan to acquire shares, the company has not lost, because the company already will make a profit from the interest that you are paying on the loan. The third one is employer share scheme. Employer share scheme. The view is held in corporate governance that workers are incentivized or are motivated to work hard where they have a stake in the company. So therefore, let them also get shares in the company. Their salaries, they will certainly not use their salaries to acquire shares, because that's what they live on. So the company could come up with a scheme and say, okay, anybody who has worked for, let's say, 5 years or 10 years or more, whatever period, this money is available. You can take the money, for example, either interest-free, and you have to use it to buy shares in the company, or we are going to be paying certain bonuses, but the bonuses are not going to be paid to you. They are going to be used for purposes of acquiring shares so they have a stake in the company. Now, that is permissible. So that one, even if you have directors who are also employees, what they call like the executive directors, they will be eligible to participate in this employee share scheme. The fourth scenario, so maybe like the employee share scheme, you look at it clearly, is not really the company losing money, in the sense that when the employees or the workers are very motivated, because they know that now if the company should make more profits, they're also shareholders. When dividends are paid, they're going to get part of the dividends. They work very hard. So it's definitely going to augment the wherewithal or the lot of the company. Now, we also had the fourth scenario, as he read, that is employee loans. It is possible for the company to create a loan for employees, which is different from like the special scheme. So where it is a loan, the company will say that, yes, we have a loan. You can take the loan and use it to acquire shares. You even pay interest on the loan, maybe a special interest arrangement and so on. That is fine. Directors who are employees are excluded from such a loan. The reason being that they are the people who make a decision as to who qualifies to get the loan or who should not be given the loan. And that is why we don't want a situation where they'll be giving loan to themselves. Maybe they'll give a very low interest rate to themselves, but for other workers, they'll give the loan to them at a very high interest rate. And then in the process, disadvantage them, and they will favor themselves and able to acquire more shares. So we want to guard against that. And that is why section 60 D, for example, exclude directors from actually benefiting from such employee loans to get their shares. The fifth scenario is about lawful dividends. We have noted already that where the company makes profits, a portion of it is declared as a dividends and distributed or shared to shareholders. Now, where the company has actually declared dividends, and the emphasis here is lawful dividends. Lawful dividends in the sense that there are various conditions or requirements which will have to be satisfied under law before the company can say that it is safe for us to earmark this portion of the profits or surplus made from the company as available dividends to be distributed to shareholders. There are certain requirements which must be met, a litmus test which must be satisfied. And that is important because that ensures that the company will be financially healthy and a going concern even after distribution of the dividends. And that is why there's emphasis on legality of dividends or lawful dividends. Now, where the company has actually satisfied all legal righteousness with respect to proper declaration of dividends, and dividends have been paid to you as a shareholder, and you decide to use your portion of the dividends to acquire more shares, you have not done anything wrong because that is your money. Your existing shareholder, lawful dividends have been declared, you'll be given your share, and you decide to use it to acquire more shares. You haven't done anything wrong. And that is actually encouraged. So let us keep that in mind. And then we also have the situation where we have what we call capitalization, for example, capitalization issue, where shareholders, instead of being given their dividends, they are given more shares and they do not pay any fresh money from their pockets as a consideration for the shares issued. That one is legitimate because to start with, they have monies which will be given to them as a dividends. The dividends is not given, it's plowed back into the company. Okay? It's injected back into the operation of the company. And then in return, they are given a corresponding number of shares, which are appropriate for the amount of dividends that which ought to be paid to them. So that one is also permitted. And then finally, we have talked about the 60F. If we have a public company, right, which would like to go into, let's say, a stock exchange, you want to have your securities, shares, and so on traded in on the stock exchange. Now, stock exchange regulators or authorities, they have rules of operation. The ground rules to have your securities listed. They usually want to deal with companies which are tried and tested so that they don't come and mislead the public. So they may have a ground rule and say that, okay, before we would list you as a listed company so that you can have your shares traded in, you must be able to raise a certain amount, a certain quantum of stated capital, or must be able to give a certain number, issue a certain number of shares of your registered shares. If you can do that, then we are confident that you are a solid company and we will enroll you on our markets. And because when you enroll in a stock exchange, what it means is that your securities are more, they move. It can be acquired and offload anytime. People can even go to brokerage firms and so on just to acquire and offload anytime. So that is very easy. It's highly tradable. So you want to be able to do that, and you need to invest in that. And investing in that will mean that two things. Either you get massive invitation to the public done, in which case you do a lot of publicity, prospectus and so on. Get your agents, brokerage firms to do so many other things to get members of the public to subscribe. That is one. Or it may well be that you want to get a solid brokerage firm, a solid firm, jobbers, who are prepared to underwrite all the shares which are available to be issued. So therefore, if you are going to look for, let's say that 1 CD per share, they'll say that we are going, if you have maybe like 1 million shares, and you're going to look for 1 CD per share, meaning that we're looking for 1 million Ghana cedis for those shares, who else will be able to qualify and be admitted into the stock exchange. And you want it to happen fast, because if you have to do just issuing it to interested shareholders, it may take a long period of time before you reach the mark, and you don't want to wait that long. So you get an underwriter, a company like which will underwrite and say that, okay, we are prepared to take all the 1 million shares. I will not pay 1 CD per share. We want to pay less than that. So you want to pay maybe for, instead of 1 CD, you pay 8 pesos. You pay 8 pesos. So that later on, when we get people to sell to them, either at 1 CD or 1 CD, 20 pesos, the difference will become our profits. And that is the gain we're also making by underwriting your shares for you. Now, certainly, if the company, for example, agreed to allow you to take it for 8 pesos per share instead of the 1 CD, the company, in a sense, is losing about 2 pesos. Now, Section 60F says that that is not really a big problem because of the purpose for which those arrangements are being made, to enable it to be, for example, be listed on the stock exchange and so on. So let's look at Section 61, that is acquisition by the company of its own shares. 61 to 67, discussing that. Yes, Section 61. Our reader has disappeared there.
No, please. Section 61. Acquisition by a company of its own shares. Despite Section 58, a company may A, create and issue preference shares which are, or at the option of the company, are liable to be redeemed and may convert existing shares, whether issued or not, into those redeemable preference shares subject to Section 62 to 65. B. Purchase its own shares subject to Section 63 to 67. C. Acquire its own shares by a voluntary transfer to the company or to nominees for the company subject to compliance with Section 62 to 65. And D. Acquire its own shares pursuant to the buyout provisions in Section 222. 2. For the purpose of Section 1, shares shall not be redeemed, purchased, or acquired by the company so long as there is an unpaid liability on those shares. 3. A company may forfeit the shares issued with an unpaid liability.
Have we lost him? I think we've lost our reader.
I'll continue, my lord.
All right.
Yeah, a company may forfeit the shares issued with an unpaid liability for non-payment of the sums of money due and payable on those shares. 4. On redemption, purchase, acquisition, or forfeiture, shares shall be available for reissue by the company unless a company, by amendment of the constitution of the company, cancels those shares. 5. Shares which are cancelled by virtue of the constitution of the company shall, until reissued or cancelled, be referred to as treasury shares. 6. Except as provided in Section 69, a redemption, purchase, an acquisition, or a forfeiture by the company of the shares of the company, or the cancellation of shares so redeemed, purchased, acquired, or forfeited, shall not reduce the stated capital of the company. 7. Voting rights shall be exercised, and dividends shall not be
exercised.
sorry. Voting rights shall not be exercised, and dividends shall not be payable on treasury shares, and except where otherwise stated, treasury shares shall not be treated as issued shares within the meaning of this act.
Okay, right. All right, good. So, Section 61, again, taking us back to Section 58 1D. Section 68 1D, as a general rule, prohibits the company from acquiring its shares by way of purchase, that is, buying its own shares or some other means. Now, that provision is very important, and it is worth recalling the case of Trevor and Whitworth, which we have already alluded to, because Trevor and Whitworth problem, we could say that, in a sense, the careful calibrated regime, what we have under 992, particularly section 61 to 67, may be seen as a solution to the problem which came up in Trevor and Whitworth, as it were. So we see that the law permits the company to acquire its own shares, so long as certain safeguards provided or embedded in the law are observed. And very soon, we're talking about the shall these accounts, retained earnings, and then the treasury share, and so on, as we have seen. So it's permissible for the company to have what they call like a redeemable preference shares. The company can create a redeemable preference share. And redeemable preference shares means that the share has the feature which enable the shareholder to trigger redemption or to take certain steps for the shares to be returned to the company or to be acquired back by the company, so that the shareholder will get his or her money and leave the company. That is why we call it redeemable. Redeemable means that it can be redeemed. It can be given back to the company and you get your money back. Now, that will have to be done under strict arrangements, so as to ensure that the capital position of the company is not unduly affected, so as not to undermine the capital maintenance doctrine. And again, even where shares were not issued as a redeemable preference shares, they can be converted to become redeemable preference shares. So that one is also permitted. And of course, under certain conditions, the company can acquire its own shares. We are going to be discussing that pretty soon under section 63 to 67. And it is also possible for a voluntary transfer to be made to the company, for somebody to say that, well, I'm no longer interested in the shares. Company, give back your shares. And it may not require the company paying any money back to the shareholder. So that one is not seen as the company reducing its capital position. It is also possible under certain condition, particularly when it comes to matters relating to what we called remedy against oppression, as it were, or the company trying to do arrangements or some other things, and a shareholder, for example, is not agreeable to the proposed arrangement, or a shareholder is saying that the affairs of the company are being run in a manner which is, for example, oppressive or prejudicial to his interest as a shareholder. The courts have looked into it, inspectors have looked into it, and let's suppose that appropriate remedy is for the shareholder to be allowed to get out of the company, for his investment will return to him. So that can also be done under section 61 1D, which makes reference to section 222. Now, certain basic things we should note is that even where you have redeemable preference shares and you have to redeem them, or the company will have to purchase or acquire them, as the case may be, that can only be done where there is no unpaid liability, where you do not have any unpaid liability on those shares. Meaning that if the shareholder has not finished paying for the price which was supposed to be paid for the shares issued to the shareholder, when the redeemable preference share were issued to him, he's not finished paying for it, then the company cannot redeem it. The company cannot allow the shareholder to redeem it, to have the shares returned to the company and he getting the money back. Because in any case, that shareholder is even owing the company with respect to the unpaid no value on those shares. And that is why Section 61 3 says that if you have unpaid liability, then you cannot actually have the redemption done. In any case, the company may even exercise the right of forfeiture, the right of cancellation. If shares have been issued to you, you've paid just a portion of it, and the other portion remain unpaid. The company has served calls on you, it made demand notice on you, come and pay. You are not paying. The company reserves the right to cancel your shares, to forfeit it, exercise the right of forfeiture, so that you lose your shares, and whatever money that you paid for the shares will not be given back to you, and you'll not be a shareholder. So that one is also permissible. And that way, the company will not have to actually pay any money back to you. So let's keep that in mind. And where the company has actually acquired back shares by way of redemption or by purchase, or the company has even exercised the right of forfeiture to cancel certain shares. Those shares were previously issued and they have come back to the company because of redemption, because of purchase back, or because of the company exercising the right of forfeiture, as the case may be. So it has come back to the company. Now, the Companies Act treats shares which were previously issued and have been returned to the company by way of redemption or forfeiture or purchase as what we call a treasury shares. Treasury shares. So treasury shares were shares which were previously issued by the company and have come back or returned to the company as a result of redemption or as a result of forfeiture, as the case may be. So let's keep that in mind. And it is the law that treasury shares, as a general rule, are not treated as part of the number of authorized shares. So if you want to deal with the, how do you call that, the number of issued shares which have been issued, we don't actually treat treasury shares as part of it. So that is very important. And again, treasury shares do not carry any votes. They do not carry any votes, and no dividends are to be paid on treasury shares because they are not treated as a general rule as what? Issued shares. And this is very important because it prevents management entrenchment. What do you mean by that? Treasury shares have come back to the company. The directors who are in charge of the affairs of the company can hide behind votes and dividends associated with those shares and behave as if they are their shares and exercise whatever rights of voting which relate to those shares. And that will enable them to, for example, entrench themselves when it comes to election of directors or removal of directors. And that is why, for good reason, the law says that treasury shares do not carry any vote. They are not also to be given any dividends. So let's keep that in mind. Let's look at section 62, redemption of redeemable preference share. Yes, take it for us, 62.
Section 62. Redemption of redeemable preference shares. Despite the provision in the constitution of the company to the contrary, a company shall not redeem any of its redeemable preference shares except A, out of a credit balance on the shares dues account referred to in section 65 or out of transfers to that amount in the manner referred to in that section from retained earnings as defined in section 71, or out of proceeds of a fresh issue of shares made for the purpose of the redemption not more than 12 months before the date of redemption. 2. Where redeemable preference shares have become redeemable and the funds of the company are sufficient to entitle the company to redeem the whole of the shares due to redemption, the holder of those shares may serve notice on the company requiring it to effect the redemption. 3. Where the company fails to redeem the shares within 28 days of the service of the notice, the shareholder who has served the notice may apply to the court on behalf of that shareholder and the other shareholders whose shares are due for redemption, and the court, if certified that the conditions of this subsection are fulfilled, may order the company to redeem the shares and may require the company and an officer of the company who is in default to bear the cost of and incidental to the application. 4. Section 205 shall apply to an application to the court under subsection 3.
Okay, good. So Section 62, as we have noted, governs redemption of redeemable preference shares. Not too long ago, we noted that under Section 61, it's permissible for the company to create redeemable preference share. A share which has the feature or the characteristics to enable the shareholder to request the company to get the share back and give his money to it. That's what I mean by redeeming the redeemable preference share. But as you can see, if it is not regulated, there is a rare challenge of undermining the capital maintenance doctrine, of depleting the stated capital of the company. And that is why Section 62 provide a very important ground rules. So the issue which arises with respect to Section 62 is that what funding sources are lawful for redeeming redeemable preference shares, particularly so not to deplete the capital of the company. So how may the company have money to be able to pay it back to a redeemable preference shareholder and get his shares back to the company without actually undermining the capital maintenance doctrine? And of course, where those lawful funding sources are ignored, and then yet the company goes ahead to redeem redeemable preference shares, what remedy exists, and so on. So the rule is that redemption of redeemable preference shares, and as I've said, when we say redemption of a redeemable preference share, we simply means that the company is taking the shares back from the redeemable preference shareholder and then give his or her money back to him. So that is a redemption of redeemable preference share. And the rule is that redemption of redeemable preference share can be done only from monies from the shareholders account or retained earnings transfers. So shareholders account and or retain earnings transfers, or 2, a fresh issue process within 12 months. When we say 12 fresh issue process within 12 months, what it simply means is that if the company is supposed to redeem certain redeemable preference shares, but it doesn't have money, but it still have some unissued shares, it can issue those unissued shares with the sole purpose of raising money to be able to pay the redeemable preference shares who are going to be giving their money and their shares taken back. In that way, the company may not be losing so much because those redeemable preference shares whose shares are being taken back and their money being given to them, we also have new shareholders who are coming. So the new shareholders who are coming, their money is what is going to be used to pay those redeemable preference shares who are going. And for that matter, it doesn't really affect the city capital so much. And that is why there are straight timelines that though the first issue of process should not be more than 12 months, and it should be sole purpose for redeeming the redeemable preference shares as it were. So let's keep that in mind. So again, you're a redeemable preference shareholder. You have given notice to the company that you want to redeem your preference share, and yet the company is not taking you serious. The law says that after you've given the notice, after 28 days, if there's no show by the company, if the company is not acting on your request, you can go to court and enforce it. But when you go to court, you have to go in a representative action, or you have to go in representative capacity in terms of Section 205, which simply means that where there are other redeemable preference shares holders who are in a similar situation as you, they too having requested the company to acquire their shares, and 28 days have elapsed and the company is not doing anything about it. You go to court on your own behalf and on their behalf as well. So whatever will be the outcome of the case, it will also inure to their benefit. So that is what we mean by saying that you have to go in representative capacity under Section 205. Yes, you may want to ask, what is the policy rationale of all this? The policy is simply, of course, to protect capital, maintain the capital of the company, and also protect creditors. And at the same time, ensure that redeemable preference share is also commercially meaningful. Commercially meaningful in the sense that, yes, a redeemable preference shareholder by definition doesn't want to have his shares in the company for the entire life of the company. And he or she may want to get out of the company at certain times. And that is why he acquired redeemable preference shares. So if that is the case, he should not have his commercial expectation defeated when he wants to redeem his preference shares. And that is why the law even says that when notice have been served, the preference shareholder can even go to court to enforce any default on part of the company as it was. So let us keep that in mind. Okay, so let's take Section 63. Section 63.
Section 63. Purchase by company of its own shares. Despite provision of the constitution of the company to the contrary, a company shall not purchase any of the shares of the company except where A. Shares are only purchased out of a credit balance on the shares deals account referred to in Section 65, or out of transfers to that account in the manner referred to in that section from within earnings. B. Redeemable preference shares are not purchased at a price greater than the lowest price at which they are then redeemable or will be redeemable at the next date at which they are due or liable to be redeemed. Or C. The purchase is not made in breach of Section 64.
Good. So if we look at the Section 63 and 64, they are simply reminding us about the various statutory safeguards which have been provided in the law to guide the company in purchasing its shares in a way which will not be considered as a company, for example, undermining or, as it were, depleting its stated capital. So that is the point. And that is why, for example, if the company is to purchase its own share, we are told that it must provide the funding from a particular source. It must provide the funding from the credit balance on the shareholders what? Account. And when you talk about the shareholders account, it's supposed to be a special account which is actually kept by the company, in which monies which are made by the company from fresh issues of shares meant to finance redemption are actually lodging and so on. So if the company is going to purchase its shares, the money should come from a special dedicated fund and not just any of its various components of funds or capital, as it were. So that is very important. And again, where it is a redeemable preference share and the company is going to redeem it, the company must not give money which is more than the money at which such a preference share could have been redeemed. What do you mean by that? Redeemable preference share is a share. And for that matter, at every point in time, we need to find out how much is the company share worth. And mind you, we operate no par value share regime. So you don't have any fixed nominal price or value superimposed on a share. And the true value of a share is determined from time to time according to the performance or the worth of the company, the net worth of the company, after adjusting its various assets and liabilities, income expenditure, and so on. The net worth as against the total number of issued shares will give you like the actually the net worth of the company, then the true value of a share. So when you are going to redeem redeemable preference share, you must do proper determination of how much the company share is worth at that time. And don't pay more than that to the shareholder. If you pay more than that to the redeemable preference shareholder, you are sinning against the capital maintenance rule. You are giving this money away. But then if you pay the exact value or less than that, then you are conserving the capital of the company and you are within the spirit of Trevor and Whitworth, and then the prohibition regime in section 58. So let us keep that in mind. So when the company is going to buy back or purchase its shares for it to be lawful, basically you said funding of it must come from the shareholders account or the retained earnings. And two, there's a price cap for redeemable preference shares. You cannot pay more than the true value for shares at the time. And of course, the company must also comply with the section 64. Section 64 will tell us about the fact that we shouldn't have more than 85% external holding as far as the company shares are concerned. And the point of trying to have all these rules or the policy rationale is actually to stop what you call the buybacks, buyback of shares being disguised distribution, because you can use this redemption or buying back of shares as an indirect way to be distributing the the money or the assets of the company to shareholders, and that will deplete the capital. That will be prejudicial to creditors of the company. Good. So let's look at section 64 briefly. Section 64.
Section 64, limit
Yes.
on number of shares acquired. 64.1, a transaction shall not be entered into by or on behalf of a company by which the total number of its shares or of its shares of any one class held by persons other than the company or its nominees becomes less than 85% of the total number of shares or of shares of that class which have been issued. 2. For the purpose of subsection 1, redeemable preference shares shall be disregarded. 3. Where after shares of a class have been issued and the number of those shares has been reduced, subsection 1 shall apply as if the number of originally issued, including shares of the class cancelled before the reduction took effect, had been the number as so reduced.
Okay. So basically, the company cannot enter into transaction that reduces outside holdings below 85%, either totality of all shares, or if you are using the various classes of shares, whichever way you are looking at it. And we do not take redeemable preference shares into account in trying to find out whether the company has actually exceeded this 85% rule. And the point is to prevent excessive self-ownership. That is, the company, in other words, the company cannot buy back or acquire shares so much so that the shares that the company has acquired, if you compare it with what shareholders are having, like the shareholders have less than 85% of that which the company has acquired back, that is not good. That is not permissible. So shareholders, that is, holders of the issued shares, must at least be 85% more than what the company is going to buy back or acquire back. And of course, we do not include the redeemable preference shareholder. Conceptually, redeemable preference shareholders, they have the feature of what? Redemption, and appropriate circumstances where the company has the money to find the redemption. So if, for example, a company already has 12% treasury shares, okay? The company already has a 12% treasury shares. It cannot buy a further 5% of that class, which will leave those outside with 83%. So if the company has taken maybe like either particular class of shares, whether by buyback or any of the means, a certain percentage came to the company. Then, if the company is going to do any transaction in terms of buying back or purchasing of shares falling within that class, the company will have to respect the limit on the number of shares acquired under Section 64 and ensure that all the time the company does not allow the the external holding, that is the shareholders out there, altogether to be less than 85%. The company cannot engage in transaction which will let the company have acquired or buy back shares, letting what shareholders have becoming less than 85%. So let's keep that in mind. Now, let's say a few things about shareholders' account, section 65. Section 65.
Shareholders account, where a company first redeems or purchases any of its shares, otherwise than on redemption of redeemable preference share out of the proceeds of a fresh issue of shares in accordance with paragraph B of subsection 1 of section 62, it shall open a share deals account and shall credit to that account a sum of money not less than the amount of money to be expended on the redemption or purchase by transferring that sum from retained earnings as defined in section 71. 2. There shall be debited to the share deals account the sum of money which the company shall from time to time expend on the redemption or purchase of any of the shares of the company, otherwise than on the redemption of redeemable preference shares out of the proceeds of a fresh issue of shares in accordance with paragraph B of subsection 1 of section 62. 3. The net price or the value of the consideration received by the company on the reissue of any of the treasury shares of the company shall be credited to the shares deals account. 4. If at any time the total amount of money to be debited to the shares deals account under subsection 2 exceeds the amount of money credited to that account in accordance with subsection 1, 2, and 3, an amount of money equal to the excess shall be transferred to the credit of that account from retained earnings, and a purchase or a redemption, otherwise than a redemption of redeemable preference shares out of the proceeds of a fresh issue of shares in accordance with paragraph B of subsection 1 of section 62 shall not be made by the company unless its retained earnings is sufficient to enable the transfer to be made. 5. An amount of money shall not be debited or credited to the share deals account otherwise than in accordance with subsection 1, 2, 3, and 4, except on a transfer to stated capital in accordance with section 68 or under an order of the court under section 80 or 239. 6. A true copy of the share deals account showing the class and number of shares involved in each transaction and the price paid or received for those shares shall be kept in a separate book at the registered office of the company and shall during business hours be open to the inspection of a member without charge and of any other person on payment of a fee prescribed by the company.
Okay, so we can leave that there, and then we jump to section 70 and 71, and then we explain them together.
Section 70, meaning of reserves. The reserves of a company with shares is the amount of money by which the asset of the company, other than unpaid calls and other sums of money payable in respect of the shares of the company, and not including treasury shares, less the liabilities of the company, as shown in the account of the company prepared and audited in accordance with Section 127 to 142 exceeds the stated capital of the company. Section 71, meaning of retained earnings. The retained earnings of a company with shares is the reserve as defined in Section 70, less the amount of money attributable to A, an unrealized appreciation in the value of an asset of the company, other than an appreciation in the value of an asset as would, under normal accounting principles, be credited to the income statement, unless the amount of the appreciation has been transferred to stated capital, and B, a balance standing to the credit of the share deals, or the balance standing to the credit of the share deals account immediately before the ascertainment of the retained earnings.
Okay, so you don't have to worry yourself about the accounting nuances of share deals account with respect to Section 65, Section 70, and 71. Those who prepare company accounts as accountants, they appreciate the accounting nuances very well. But for us as students of company law, it suffices for us to appreciate that, yes, there is a certain dedicated account we call the share deals account, and that the company must open and credit the share deals account on first redemption or purchase of shares, as we have read, and that the company must make debits, that is, take no money from that for purposes of a redemption or purchase. And then where there has been any reissue, for example, we talk about treasury shares. Treasury shares are shares which have been redeemed or forfeited and then is being held on by the company. It's not yet be given out, so it's not also be cancelled. So they are called the treasury shares. They were once issued, but they have been acquired or come back to the company. They've not been issued there, so they are treasury shares. So assuming the company's constitution permitted to, let's say, to reissue it, and it is reissued, the process which will come from it will have to be credited to the shareholders account, and also under appropriate circumstances, transfer of money may be made from the retained earnings. And we've seen the meaning of retained earnings in terms of Section 70 and 71. Transfer may be made from the retained earnings, assuming there is a shortage of funds in the shareholders account, as it were. And to ensure that there is no abuse of the shareholders account, it is an account which is supposed to be available for scrutiny or inspection. Other shareholders or people interested can go to designated place where the shareholders account and actually inspect it to know exactly what is happening, as it were. So it seeks to ring-fence no buyback arrangement of shares or provide no redemption funding, and also create some transparency to members and regulators, and all this ultimately achieve capital maintenance and bring about accountability as far as corporate governance is concerned. So, for example, if the company buys shares for, let's say, 500,000 Ghana cedis, it must ensure that the shareholders account is credited by at least 500,000 Ghana cedis from the retained earnings, and then it will be debited on the purchase. So that is very important. For as I said, these are accounting nuances, so we shouldn't worry about it. And again, if we look at the section 66, you will notice that some modifications of what we'll be discussing under section 61 to 65, so long as they apply to authorized mutual funds, have been adjusted appropriately, as it were. And for that matter, section 66 will tell us that any of the things that we'll be discussing under section 61 regarding acquisition by company of its own shares or redemption of redeemable preference shares purchased by a company of its own shares, or the limit on the number of shares acquired, especially the 85% rule, and then the shelf this account. These may be waived or may be modified by the registrar of company in relation to companies which is, for the time being, an authorized mutual fund under the Security Industries Act, 2016 Act 929. So companies which are in the security industries, the mutual funds, and so on, they are given certain exemptions or certain modifications with respect to how some of these things actually operate, because they are also subject to another higher layer of regulatory regime. So we want to avoid regulatory duplication, and that is why mutual funds operate under security-specific protection architecture, and that is the point of section 66. So let's keep that in mind. So let's quickly look at the reduction of capital under section 69. Can we look at that reduction of capital 69?
Section 69. 1. Despite subsection 4 of section 61, the stated capital of a company shall be deemed to be reduced by the amount of money by which a redemption of redeemable preference share is made out of the proceeds of a fresh issue of shares made for the purposes of the redemption, not more than 12 months before the date of redemption. 2. An limited company may reduce its stated capital by ordinary resolution. 3. Subject to subsection 1 and 2 and to section 66, a company may not reduce its stated capital except in accordance with section 78 to 82.
Good. I'd like you to quickly jump back to section 61.4. Section 61.4, so that we'll explain them together.
Section 61.4. On redemption, purchase, acquisition, or forfeiture, shares shall be available for reissue by the company unless a company, by amendment of the constitution of the company, cancels those shares.
Good. Yeah, so the point about section 69 is that when does redemption of redeemable preference share or buyback of shares by the company produces a capital reduction, and when is reduction procedurally restricted under the law? So, as we just read under 69, we have deemed reduction in the specified redemption as stated under 69. That is where you have fresh issues of proceeds within 12 months used to finance redemption of a redeemable preference share. Then we are told that that in itself will be treated as a reduction of the stated capital. And of course, we've always seen that unlimited company for them is very flexible. They can just reduce their stated capital by ordinary resolution. Yeah. So let's keep that in mind. And the point about all this is to actually to preserve the protection of creditors by ensuring that capital reduction, for example, is properly regulated or is supervised by the court, as you notice, because as we will see very soon, when it comes to the, let's say, the resolution requiring approval by the court, particularly under section 78 up to section 82, you notice that there are certain safeguards which are provided to ensure that if capital is going to be reduced in any other way, then it should be properly regulated so as not to, again, hurt the interests of shareholders. So let's keep that in mind. But we come and discuss section more about section 78 to 82 with respect to court confirmed capital reduction very soon. We'll come back to it very soon. So let us quickly discuss legality of evidence before we move on. It's a very important component of capital maintenance. So section 72. Section 72, take that for us.
Section 72. 1. Except in winding up, a company shall not pay a dividend to the shareholder of the company, or, except in accordance with section 78 to 82, make a return or distribution of any of the assets of the company to the shareholders of the company, unless the company has complied with the distribution test. 2. Where a payment, return, or distribution is made in contravention of this section, A, every director of the company who is in default is jointly and severally liable to restore to the company the total amount of money by which the payment, return, or distribution contravenes this section, with interest on that amount at the yearly interest rate of the 91-day government treasury bill. 2. Unless within 12 months after the date of the payment, return, or distribution, the total amount of money with interest on the payment, return, or distribution is restored to the company by the directors in accordance with paragraph A of this subsection, every shareholder is liable to restore to the company the amount of money received by the shareholder in contravention of this section. And C, if the directors of the company make a restoration to the company in accordance with paragraph A of this subsection, they shall have a right to be indemnified by a shareholder who has received an amount of money knowing that it contravenes this section to the extent of the amount received by the shareholder with interest on that account at the yearly interest rate of 91-day government treasury bill. 3. A shareholder, an officer, or a creditor of the company, or the registrar may apply to the court for an injunction restraining a company from paying a dividend or from making a return or distribution in contravention of this section, or for an order for restoration in accordance with subsection 2. 4. An application by a shareholder or creditor shall be made in a representative capacity on behalf of the shareholder or the creditor and the other shareholders or creditors of the company, and subsection 205 shall apply. 5. In relation to public companies, paragraph B of subsection 2 shall be modified as stated in section 3 20.
Good. I would like you to go to the interpretation section and read the meaning of the distribution test. Now, when you read section 72, there was an allusion to distribution test. So when we say distribution test, what does it mean? So let's go to the first schedule. That is page 304, distribution test. Yes, read it. Are you there? Or anybody?
Please, I'm searching.
Anybody who is there can take a
Minor
distribution test.
distribution test includes circumstances where a company is able to pay its debt as they fall due, and B, the amount or value of any payment, return, or distribution made by the company does not exceed its retained earnings immediately before the making of the payment, return, or distribution.
Good. So section 72, as the section subheading indicates, legality of dividend. So the point about it is to address the issue. When is a dividend unlawful? And who bears liability for unlawful dividends? I know we have already explained the meaning of dividends, and we said that dividends is basically the returns a shareholder makes on a share which he has in a company. When profit is made by the company, the profits, a portion of it is earmarked as being available to be distributed to shareholders. So portion of the profit earmarked to be distributed, when so distributed to the shareholders, is treated as the dividends. Now, there's a challenge. It may well be that the company is not really financially healthy. And for that matter, it's not safe for dividends to be paid. And that is why section 72 is there to police or discipline lawful payment of what? Of dividends. So where dividends has been declared or paid, contrary to what the law says, who bears liability for such unlawful distribution? So as we have read, the general rule is that no dividend or no distribution of dividend is to be made unless the distribution test is satisfied. The only exception being winding up. Because winding up, usually when it comes to winding up, voluntary winding up, there will have been what we call the insolvency tests having been made that the company is able to pay its debts and liabilities as they fall due. So there's nothing to really worry about. And that, so especially members voluntary winding up, as opposed to maybe like the official liquidation or compulsory liquidation, as the case may be. So if you are doing winding up, once you pay creditors and so on, and you've taken care of all your liabilities, nothing is left. You still have some assets left. You can distribute dividends to shareholders as it were. There's nothing wrong. And that one will not have to worry itself about this legality test because we have already sorted out third parties or creditors. And what is left is just the shareholders. But other than that, where the company is not winding up, the company is still in business, or hopefully is a going concern. If you are going to declare dividends, you have to make sure that you have met the distribution tests. And distribution tests, if you look at the first schedule or section 383, the definition section of the Companies Act, Act 992, we are told that distribution test includes circumstances where a company is able to pay its debt as they fall due. And you call this in corporate finance, you call that the company is a going concern. if the company is a going concern, so that the company is able to pay its debts as they fall due. It's a going concern. And B, the amount or value of any payment, return, or distribution made by the company does not exceed its retained earnings immediately before the making of the payment. So long as the company is a going concern, and then the company is going to make distribution which will not exceed its retained earnings. Retained earnings, as we have already discussed in session 71, then what it means is that it is lawful for the company to pay dividends. So that is very important. So quite apart from whatever the company may provide in its constitution regarding payment of dividends, this statutory test must also be met. The statutory test we call the distribution test. And the company is, first of all, a going concern, is able to pay its debts as they fall due. And two, the company is not going to pay as dividends more than, or is not going to pay dividends which will, for example, let the retained earnings, for example, of the company go down after the payment of the dividends. So let's keep that in mind. So no dividends unless distribution test is satisfied. And where directors of the company, because there's a director of the company, that will usually see to payment of dividends. Those of you who are shareholders, like some of us at least, thank God I'm one of the significant shareholders of the Dr. Rural Bank for many years before I became a judge. And what happens is that, I also serve as a director for, I think, for about 17 years or something like that. So we review the financial statements and we'll be in a position to determine the profitability of the company, its position on the vis-a-vis various statutory requirements. And then we will suggest to shareholders that we think that in view of XYZ, this amount of profit which have been made can be distributed as what? As dividends. So we will make the proposal, and then the shareholders will have to pass the resolution to approve the dividends. And later on, when we are discussing corporate governance, of course, last we discussed members and their meetings. You notice that when it comes to annual general meeting, usually one of the items on the annual general meeting is to declaration of what? Of dividends, as the case may be. So the shareholders will now pass a resolution to declare dividends. But the shareholders on their own cannot bring up the resolution. It will have to be recommended by directors. And that is where directors recommend, or directors will pretend over payment of dividends, contrary to the safe levels prescribed by the law. Then there will have to be sanctions. So the directors involved will be made to refund the amount of money they have unlawfully paid as dividends to the shareholders back to the company. And shareholders too, who have benefited from the illegal or unlawful dividends, the directors who have been made to restore it back to the company can sue them to recover those monies, so they can be indemnified. So they can sue those shareholders who benefit from the unlawful dividends and get indemnity. That is, get reimbursement for them for whatever money that they have also have to pay back to the company for paying the unlawful dividends to these shareholders, as it were. So if the directors will not restore within 12 months, the shareholders will have to restore. And again, it is permissible for a shareholder to go to court and say that the company should impose an injunction to restrain the company from actually declaring dividends, as it were. So let's look at that. And the point about all this is to ensure that the company is solvent. If the company is not solvent, it shouldn't be declaring dividends. It will also undermine the interest of creditors. And directors are not supposed to treat dividends as a favor, which they are doing to shareholders, so that shareholders will keep on voting for them. No, they must ensure that the requirements of the law, as far as payment of dividends are actually met before recommending dividends for payment. So let's keep that in mind. Okay, so let's look at the situation of unclaimed dividends, Section 73, which is a new addition to the law because it wasn't part of the old law at 179. So Section 73 is one of the new additions to the law. Let's quickly look at it. And then 74. So let's read the 73, 74 together quickly.
Section 73, unclaimed dividends account. Where any dividend declared by a company cannot be paid by reason of the dividends being unclaimed by the member entitled to the dividend and remains unclaimed for a period of 3 months, the company shall forthwith A. Open an interest-bearing unclaimed dividend account, and B. Credit to that account the total amount of the unclaimed dividend of its shareholders unless that account has already been opened. 2. Where payment of the dividend cannot be made or is not claimed within a further period of 12 months after the transfer made under paragraph B of subsection 1, the company shall pay to the registrar the total amount of the unclaimed dividend plus interest accrued on the amount. 3. The registrar shall pay into the account under subsection 4A the amount received under subsection 2 and B, the amount received under subsection 3 of section 74. 4. The registrar shall, with the approval of the board, open an interest-bearing bank account for the safekeeping of monies received from any company under subsection 2. 5. The registrar is responsible for the monies lodged and disbursed from the interest-bearing account. 6. The company shall, on the date of the payment under subsection 2, notify the respective shareholder or the estate of the shareholder at the last address known to the company of the payment made in respect of the dividend. 7. The shareholder or the estate of the shareholder shall, on providing satisfactory evidence, be entitled to make a claim for the dividend and any accrued interest during the period that A company had possession of the dividend under subsection 1, and B, registrar had possession of the dividend under subsection 3. 8. The registrar shall publish annually in the company's bulletin and in a daily newspaper of national circulation details of shareholders whose dividend have been transferred to the registrar for safekeeping. 74. Management by registrar of unclaimed dividend account. 1. The registrar shall keep unclaimed dividends lodged in the account under subsection 4 of section 73 for 7 years. 2. The registrar shall, on the expiration of the 7-year period referred to in subsection 1, A, transfer to the consolidated fund 50% of the total amount of money lodged with the interest-bearing account under subsection 4 of section 73, and B, donate or apply 50% of the total amount of money lodged in the interest-bearing account under subsection 4 of section 73 for the purpose of investor education, research, entrepreneurial development, and advancement in company law. 3. Where a company on the commencement of this act has in the possession of the company unclaimed dividends, the company shall immediately transfer the total amount of the dividend to the registrar to be applied in accordance with subsection 1 and 2.
Okay, good. So as I indicated section 73 and 74 largely some of the novel provisions in our company's legislation, because you don't see its equivalent in the repealed at 179. So what 73 and 74 is trying to do, address the issue of where the company has declared dividends. A shareholder is not coming to collect or claim his dividends, which is due him by reason of the shares that he has. Either he has traveled or he's dead or something like that. So what must a company do with the declared dividends that remain unclaimed? And that is why section 73 is telling us that after 3 months of declaring the dividends, if it's unclaimed, the company must open interest-bearing unclaimed dividend account and credit all dividends which have not been claimed by the shareholders in that account. And it will be yielding interest, as it were. Now, after 12 months, if it's still unclaimed by the shareholders, the company must transfer the money to the registrar of companies with all the accrued interest. And notice is supposed to be made available to shareholders or estate, that is the estate of a deceased shareholders, shareholders who had shares and have died. Dividends are declared so that their personal representative or beneficiaries of the estate will take the necessary step with the requisite evidence. And I like section 73 8. And I would like to challenge you. It's an opportunity for you as law students and lawyers to hold the register of companies to account. Since Act 992 came into force, I haven't seen any publication in the Daily Graphic or any newspaper doing what section 73.8 says the register of companies should do. Section 73.8 says that the register of companies shall publish annually, that is every year, in the company's bulletin and in a daily newspaper. So daily newspaper of national circulation, either Daily Graphic, Daily Guide, or any of the newspapers of national circulation. Details of shareholders whose dividends have been transferred to the registrar for safekeeping. So first of all, the registrar of companies doing this work well? I don't think so with respect to this aspect of the law, because we don't see anything unless someone has seen one and I am not aware, in which case I stand to be guided. Now, the register of companies is supposed to, for example, police companies, follow up on companies that have declared dividends and ensure that they send their auditors or inspectors to go and find out. Since declaring the dividends, 3 months have elapsed, 12 months. Have all the shareholders come for their dividends? If no, where is it? And I have 3 companies I have shares there. Because of my location, I haven't had time to go to Kumasi and follow up on dividends. So I can say that the past 3-4 years, in some of the 5 years, they've declared dividends. I haven't gone for mine. And I haven't seen my name, for example, being published anywhere. I haven't gone for my dividends. And that is why I said that section 73 and 8 is not actually being implemented. But the good thing is that when you're a lawyer, you can actually worry the register of companies by writing the necessary letters and also under the Right to Information Act to request certain disclosures. Now, when they are not made, you can go to court and then let the court compel the registrar to do the deed for, as it were. So the point about section 73, the policy underpinning, is to protect absentee shareholders. Either they have traveled or they are deceased, as it were, and also prevent indefinite retention. That companies should not hold on to dividends which have not been claimed time without end. And there should also be misuse of unclaimed dividends by companies. There should be transparency through publication, as I have indicated. And if we look at the 74, as we have just read, where dividends have been unclaimed, okay, the company has, having held on for 3 months and then 12 months, it's forwards the money to the registrar of companies. Now, what happens to the unclaimed dividends once the registrar holds them? What is the end point? Must the registrar hold the money forever? No. The registrar of companies is to also keeping in its account for 7 years, okay? After 7 years, if they're still unclaimed, then the money is supposed to be shared between the registrar of companies and then the Consolidated Fund of Ghana, one of the major, constitutional, public fund in which, money for keeping the states is actually kept, the Consolidated Fund. So 50% of the unclaimed dividends after 7 years will be paid into Consolidated Fund, and then 50% will be paid into specified public interest purpose, which will be used for various matters, including matters relating to the registry of companies and also research and advancement in company law and so on and so forth. Let's look at section 75 quickly. Section 75 and 76 together, and 77. Let's look at them quickly together before we get towards the end. Yeah.
Section 75. Prohibition of payment of dividends by companies limited by guarantee. 75.1. A company limited by guarantee shall not at any time pay a dividend or make a distribution or return of the asset of the company to members of the company. 2. Where a payment, distribution, or return is made in contravention of subsection 1, a member to whom it is made shall restore same to the company with interest at the yearly interest rate of the 91-day government treasury bill. And every officer of the company who is in default is liable to pay to the registrar an administrative penalty of 500 penalty units.
Now, before you move on, I mean, in terms of a company limited by guarantee, this is beyond debate. We have seen earlier on that company limited by guarantee, they are not supposed to engage in any, if you like, the profit-making business, except matters in furtherance of the object for which it is set up. And that is why Section 75 is saying that there is absolute prohibition on company limited by guarantee as far as payment of dividend is concerned. They cannot share profit as dividends because they are not supposed to be doing that. And that if they have done that at all, they will have to actually restore it, and interest will have to be paid on it. And the officers who are cognizable of these infractions will have to bear penalty, up to 500 penalty unit, as it were. And the point about this section 75 really is to preserve the non-distribution purpose of company limited by guarantees, and also to prevent conversion into disguised profit vehicles. So if you decide to convert your company limited by shares, for example, to guarantee, then that is it. But you cannot still convert it to limited by guarantee and you hide to share profit among yourselves. That is what section 75 is actually reminding us of. Let's look at 76.
Section 76, declaration of dividends. 76(1), subject to subsection 72 and 75, and in the case of private company, each registered constitution where applicable, a company may, by ordinary resolution, declare dividends in respect of a year or any other specified period, but a dividend shall not exceed the amount recommended by the directors. 2. In relation to public companies, subsection 1 shall be supplemented by section 321. 3. A dividend shall be paid within 60 days after the resolution of the shareholders confirming payment or after dividends have become payable. 4. Where a dividend is to be paid in accordance with subsection 3, the shareholders shall be notified of the amount of dividend recommended by directors for payment. 5. A registered constitution of a company may prescribe modes for payment of dividend without reference to the resolution of the shareholders.
Good. So, section 76, already we have discussed legality of dividend under section 72, and section 76 is addressing the issue or the question, whose responsibility is to declare dividend? And what are the conditions, what are the limits under which dividends can be declared? And within what timelines? So the general rule is that dividend is declared by ordinary resolution. Ordinary resolution is passed by shareholders. But the passing of the ordinary resolution will be based upon recommendation by directors of the company. So therefore, the ordinary resolution declaring dividends cannot exceed the director's recommendation with respect to how much of the profit they think is safe for the company to declare as dividends and distribute among shareholders. And of course, where dividends is declared, then within 60 days, payment is supposed to be made. And the amount recommended will have to be notified as well. Of course, it's possible for the company constitution to prescribe some other modes by which dividends may be declared, so long as it's not sinning against any mandatory provision of the law. Now, when it comes to public companies, if you look at section 321, for example, it is possible for public companies to do what we call interim dividends. Interim dividends in the sense that, and that is why it's interim, because the shareholders have not yet passed, if you like, the resolution as it were. So maybe a certain portion of dividends, for example, those on the listed companies like MTN, for example, they did their IPO and we all got some small amount of shares. We're very skeptical in the beginning, so we didn't buy. Some of us didn't buy much. In my case, I bought probably less than just 5,000 or something like that. Occasionally, you are there, and then they send you this alert of interim dividend, and then later on, when the accounts have finally be approved by shareholders and so on, auditors, then they will give you like the final dividend. So that is also permissible under section 321 with respect to public companies. So let us keep that in mind. And the point about all this regime, particularly under section 76, is to ensure a certain kind of like a balance between shareholder power to ultimately declare dividends by passing ordinary resolution, and at the same time, with the directors' stewardship, because directors, they are responsible for day-to-day managerial decisions, and they are in a better position to tell shareholders that we think that having regard to everything regarding operations, the micro and macro environment of the company and everything. It is safe for this amount of money to be taken from the profit as dividends. So you're able to get that kind of like a balance. And we also have some kind of like a orderly and a timely payment of dividends, as it were. So if shareholders want the higher dividends than that recommended by directors, of course, that will be illegal. You cannot resolve to pay more dividends than that recommended by shareholders, as it were. Let's look at section 77, capitalization issue. We've discussed it already, so just will be very quick about that. Section 77.
Section 77, capitalization issues and non-cash dividends. 1. When a company resolves to transfer a sum of money from reserves to stated capital pursuant to paragraph C of subsection 1 of section 68, the company, on the recommendation of the directors, may, by the same or subsequent special resolution, resolve that on issued shares in the company be issued and credited as fully paid to the members who would have been entitled to receive that sum of money had it been lawfully distributed by way of dividend and in the same proportion, so that the sum of money so transferred to stated capital shall be deemed to be paid otherwise than in cash on the shares. 2. An issue under subsection 1 shall be referred to as capitalization issue. 3. A company, on the recommendation of the directors, may resolve that a sum of money standing to the credit of the retained earnings of the company, and which would have lawfully been distributed by way of dividend, shall be applied on behalf of the members who would have been entitled to receive, say, if it had been distributed by way of dividend, in paying up amount of money for the time being unpaid on the shares held by the members, and that sum shall be deemed to have been paid on a call made on those shares and shall be transferred to stated capital pursuant to paragraph A of subsection 1 of section 68. 4. Resolution of company lawfully declaring a dividend may, on the recommendation of the directors, direct payment wholly or partly by distribution of securities for money, or of fully paid but not partly paid shares or debentures of any other body corporate, or of fully paid debentures of the company of a nominal amount equal to the amount so directed to be paid. 5. The directors shall give effect to the resolution, and A, may make a provision that they think fit for the case of the shares, debentures, or securities for money becoming distributable in fractions. B, may issue fractional certificates, or, in the case of distribution, in accordance with subsection 4, but not in the case of a capitalization issue in accordance with subsection 1, and C, may sell the shares, debentures, or securities for money represented by those fractions and distribute the net proceeds of the sale among the members otherwise entitled to those fractions in due proportions. 6. An allotment of shares or debentures, or a pay-up of shares pursuant to the resolution, may be made without obtaining the individual consent to that allotment of the members concerned, and a transfer of shares or debentures in any other body corporate may be signed on behalf of the members to whom they are transferred by a person nominated in writing by the directors, and the signature of that person shall be effective and binding on all the members.
Good. So, of course, we have earlier on alluded to capitalization issue. This is not the first time we are meeting it. When we're discussing payment for issue of shares, we noted an important exception to the general rule that when shares are issued, they should be paid for by valuable consideration, either cash or non-cash payment. And we said that exception is the capitalization issue. And what is capitalization issue? And that is why section 77 is reminding us that where a company decide to transfer from its reserves to stated capital and issue fully paid shares pro rata, that is in proportion to the amount of dividends which have been paid to the existing shareholders. They are given the equivalent number of shares which is due for that. The shareholders do not have to pay money for those shares because dividends which have been paid to them is not being paid to them, it's being plowed back into the company. And they are given equivalent number of shares, or they are giving shares on pro rata basis. So special resolution will be passed once directors have made the requisite contribution as it were. So let us keep that in mind. And the underlying rationale is to ensure that where the company, for example, needs more capital injection and it does not want to maybe dilute current shareholding structure, and also it wants to maintain balance of shareholding or parity among entitled members, then it will go ahead and give more fully paid up shares in lieu of distribution of dividends to the shareholders, as it were. So let's know that. And finally, we want to discuss resolution confirming requiring confirmation by the court. And that will end our session for tonight. So let's look at section 78 to section 82 quickly. Yes.
Section 78. Resolution requiring confirmation of court. 1. Subject to confirmation by court, a company limited by shares may, by special resolution, reduce the stated capital of the company in any way, extinguish or reduce the unpaid liability on any of the shares of the company. C. Resolve to pay or return to the shareholders any of the assets of the company which are in excess of the requirement of the company. Or D. Alter the constitution of the company by cancelling any of the shares of the company. 2. A resolution under subsection 1 shall in this act be referred to as a resolution requiring confirmation. 3. Where the resolution requiring confirmation varies the right attached to a class of shares, the resolution shall not be effective unless section 50 has been complied with. 4. This section does not require confirmation by the court of a transaction validly effected under section 78 and 75 to 77. 5. The provision of this section and sections 139 to 141 and 156 are subject to the Securities Industry Act 2016, Act 929.
Yes, continue.
Section 79, application for confirming order. Where a company passes a resolution requiring confirmation, the company may apply to the court for an order confirming the resolution. 2. Where the resolution requiring confirmation involve diminution of liability in respect of shares with an unpaid liability, or a payment or return to any shareholder, and in any other case, if the court so direct, the following provisions shall have effect unless having regard to the special circumstances of the case. The court otherwise directs a creditor of the company who at the date fixed by the court is entitled to a debt or claim, which, if that date were the commencement of the winding up of the company, would he admissible in proof against the company, is entitled to oppose the confirmation. B, the court shall settle a list of creditors so entitled to oppose, and for that purpose shall ascertain, as far as possible without requiring an application from a creditor, the names of those creditors and the nature and amount of their debt or claims, and may publish notices fixing a day or days within which creditors not entered on the list are to claim to be and to be so entered, or are to be excluded from the right of opposing the confirmation. Or C, where a creditor entered on the list whose debt or claim is not discharged or has not determined, does not consent to the confirmation, the court may dispense with the consent of that creditor on the company securing payment of the debt of that creditor, or claim by appropriating as the court may direct the following amount. If the company admits the full amount of the debt or claim, or though not admitting, is willing to provide for the debt or claim, then the full amount of the debt or claim, or if the company does not admit and is not willing to provide for the full amount of the debt or claim, or of the amount is contingent or not ascertained, then an amount fixed by the court after the like inquiry and adjudication, as if the company were being wound up under the body's corporate official liquidation act 1963, Act 180. 3. The court may refer the application to the registrar, who shall appoint one or more competent reporters to investigate the fairness of the resolution for reduction and to report on the resolution to the court. 4. The remuneration of the reporters shall be fixed by the registrar, and the expenses of the investigation shall be borne by the company. 80. Section 80. Order confirming the resolution. The court may make an order confirming the resolution on the terms and conditions specified by the court, if satisfied. A, with respect to every creditor of the company who under Section 79 is entitled to oppose, that the consent of the creditor has been obtained, or that the debt or claim of that creditor has been discharged or secured. B, that Section 70 and 79 have been duly complied with, and C, that the resolution requiring confirmation is fair and equitable. 81. Order and minutes to be registered. The registrar, on production of an order of the court confirming the resolution requiring confirmation and the delivery to the registrar of a copy of the order and of a minute approved by the court showing A, the new stated capital of the company, B, the number of authorized and issued shares and the classes into which they are divided, and C, the amount of money deemed to be paid and the unpaid liability on the issued shares. It's distinguishing the amount paid in cash and the amount paid otherwise than in cash shall shall register the order and the minute and publish the particulars stated in the minute in the company's bulletin. 2. On registration of the order and minute, the resolution for reduction shall take effect. 3. The registrar shall personally certify the registration of the order and the minute, and the certificate is conclusive evidence that the requirements of this act with respect to the resolution requiring confirmation have been complied with, and that the stated capital and shares of the company are as stated in the minutes. Protection of creditors.
Okay, so let's quickly wind up on this. So the point about Part H of the Companies Act 2019, that is on resolutions reducing capital, shares, or liability, embodied in Section 78 up to Section 82. Now, if you look at Section 78, there's a certain phrase, especially I want you to pay attention to Section 78, subsection 2, which says that a resolution under subsection 1 shall in this act be referred to as a resolution requiring confirmation. So a resolution acquiring confirmation is a term of art. A term of art in the sense that the law has given a special technical meaning to it within the context of Act 992. Therefore, henceforth, supposing your examination, I ask you to discuss resolution requiring confirmation, you should know what I'm referring to. Because Section 78(2) is saying that any resolution which falls within 78(1), that is, if it's a special resolution by company limited by shares, seeking to reduce the stated capital of the company, or seeking to extinguish or reduce unpaid liability on the shares of the company, or seeking to pay or return to shareholders any of their assets, or seeking to alter constitution of the company by cancelling any of the shares of the company. We call that a resolution requiring confirmation. A resolution requiring confirmation by the court. So let's keep that in mind. And it is there to actually ensure that the matters which are stated over there, of course, they definitely have implication for capital maintenance as well, and they need to be properly supervised by the court. If you are going to reduce unpaid liability for issue shares, the court must come in. If you are going to, for example, reduce the stated capital of the company, the court must come in, because creditors are also going to be affected by whatever that proposed changes are going to be. And that is why the law requires that a special resolution should be passed. There's a need for confirmation by the court, so long as the resolution is going to affect or change the stated capital, or the resolution about unpaid liability reduction, or return of excess assets to shareholders, or even cancellation of shares. If the resolution seems to do any of the following, you must actually go to court for the court to confirm it. And again, if it's going to affect certain class of shareholders, and for that matter, it will amount to violation of what they call the class rights. If it will amount to violation of class rights, then we must also comply with Section 50 of Act 992, which we have seen already. But then matters relating to Section 72, as we have discussed already, when it comes to payment of dividends, or when it comes to matters relating to no declaration of dividends and so on, they do not need any confirmation. Although they too are resolution, but they are not resolution requiring confirmation. So let's keep that in mind. And the policy rationale for this provision is to have creditor protection and then oversight in terms of ensuring there's fairness by the court, so as to protect class rights and so on. So 79 requires that once such a resolution is made, there's a need for application to be made by the court to the company. By the company. The company should make application to the courts, and when application is made seeking confirmation of the resolution, any creditor who opposes the resolution, a list of those creditors will be made, and they are notified. They can also come to court and make their representation. And in appropriate cases, if the creditors are secure creditors, the court may dispense with their consent as the case may be. Or if the opposition by the creditors to the proposed, to the resolution, in respect of which the company is seeking confirmation by the court, if the position is so strong, the court may even ask the register of companies to make available investigators or reporters to go and investigate the fairness of the proposed resolution, so that the company will be able to make the requisite orders and ensure that everything is done firmly to all people who are going to be affected. And what this exercise seeks to do is as it were to, if you like, to replicate liquidation proof logic. That is where creditors will prove during winding up, where creditors will prove in the winding up that the company, for example, is not solvent or solvent as the case may be. They must also not be prejudiced by capital reduction. If, for example, you cannot do winding up, voluntary winding up, because you don't meet the solvency test, and creditors will, for example, come in and resist it, then when it comes to capital reduction, you should not be able to get it done through the back door. And that is why the courts will come in. Now, eventually, when the court is satisfied in terms of Section 80, as we discussed, the court will have to find out certain things. Is the court satisfied that there's a creditor consent or a certain security or discharge have been made? The requisite procedures have been followed. And then, if investigators were appointed to look into the fairness of the whole thing, has the court ascertained that everything is fair? Or the court may impose terms and then the conditions under which the resolution may be confirmed. And ordinarily, what all these things seeks to do is that they ensure that capital reductions or no resolution on capital reduction, requiring confirmation, do not become, if you like, a tools for oppression or creditor prejudice. And for that matter, the court should supervise to ensure that everything is legitimate and fair, as it were. Okay, so we will draw the curtain down here and then just read the remaining two provision. That is section 81 and 82. And this will mark the end of discussion of shares. We will continue discussion of loan capital debentures in a subsequent class. Unless there are some questions, we draw the curtain down here. Okay, haven't seen any hand up, so have a good night.